All right, so I have a few pieces of housekeeping, of course, an attorney, not surprising. So today what we're doing is an informational presentation. Essentially, I'm going to be conveying, like I said, some tips and some tricks to you. But if something is of interest in what I'm saying or of concern, you're really going to want to go and visit your trust and estates attorney or your other legal representatives so that you can talk about that issue or that concern, how it relates to your own personal circumstances. So I would encourage you not necessarily to act or not act based on anything that I say today. And then, of course, as you probably guessed from the title, I am a California attorney. And so I'm going to be talking about California estate plans and California law. And law is different from state to state, or as we like to say, jurisdiction to jurisdiction. And also laws do change over time. So that's just something to keep in mind. Now, for those of you who are registered today and you are in the Bay Area, as promised, I did say I was going to give you folks a code. And essentially what that means is if you email me or you call me, you're in the Bay Area and you want to set up a free 1-hour Zoom conference where we can talk about, generally your estate plan, and whether or not it might need some updating or some tweaking. This is the code that you're going to use for that free consultation. So again, feel free to call me or email me with the code review. If you're in the Bay Area, I'm happy to sit down and chat with you for an hour about your planning. And I'm going to show this code again at the end for the folks that are joining late. All right, so as I mentioned before, if anyone has joined since we started, if you have any questions as we go along, feel free to put those in the Q&A box. I'm going to be talking for about 30 minutes or so, and then again, I'll be checking the Q&A at the end, and hopefully we'll get some really great questions, and I'm happy to answer those, obviously. So most of us here, I think, are here because we know intrinsically that estate planning really isn't a one and done proposition. You can't really, draft your estate plan and then put it in that safe deposit box or put that binder on the shelf and never look at it again. I will say as a practitioner, we take great pride in drafting estate plans that are really flexible and really nimble for life changes, law changes, etc. But there are limits to what we can do, limits in terms of what we can foresee. Life is messy, life is strange, and we can't always plan for every single possible consequence or life change. I also have had the privilege of working with families on the back end, when a loved one has passed away and we have actually had to administer a plan for somebody. And you do see, and I have seen, the unintended consequences, the unfortunate consequences of what happens when you try to overplan, when you try to plan for every single possible scenario. Because I guarantee there are still unforeseen scenarios that somebody hasn't planned for. And oftentimes what happens is the scenario is a little bit different. And then again, you get those unintended consequences that I talked about. So I think what we do as estate planners is really a balance of being flexible so that you're not coming to see us every 5 minutes. But also there is a little bit of a pact between estate planners and the clients that we're working with that they're going to keep an eye on their plans as well. And if things change, they're going to call or they're going to come see us so that we can make sure that their plan still does what they want it to do. This is important because I tell folks all the time, you could have the very best plan, the Cadillac of plans put together by the best firms, the best minds in the industry. And if that plan isn't tailored to your particular circumstances, that plan is probably not worth the paper that it's printed on. And so you want to be sure that you're protecting yourself, that you're protecting your loved ones, and you're protecting your estate by maintaining and sometimes updating your estate plan. So let's talk a little bit about the timeline. I like to give folks a rule of thumb because obviously that makes it a little bit easier than guessing when you should be looking at your estate plan. My rule of thumb is you should be thinking about pulling out your plan every 3 to 5 years. And the reason for that is your life, as I've mentioned, is going to change over time, sometimes dramatically. And again, laws are not static. And so the laws are going to change over time. And people are often surprised at how many areas of law affect their estate plan. There are the income tax rules, the estate tax rules, the property tax rules, and the probate code. And these are kind of just scratching the surface of the laws that can affect your estate plan. And so looking at it every 3 to 5 years, and I know for some of you that probably seems like really often, that's almost like the annual spring cleaning that you're probably doing, every year with your house or your homestead. But every 3 to 5 years is important because you want to get ahead of any potential issues. You don't want to wait until something has happened that has affected your plan adversely. You want to be thinking about how your life is changing and how the laws are changing every few years. And this allows you to then potentially update or tweak your plan so that again, that you're protecting everything that you want to protect. So there are some types of changes in your life that are going to be dramatic enough that maybe you want to think about looking at your plan more often than every 3 to 5 years, or maybe in the interim between when you might normally be pulling out that plan to take a look at it. And that's because these are the types of life changes that are dramatic enough that you very likely have to update your estate plan. And so it's not necessarily an if, but a when. And so some of these are going to make perfect sense as you're looking at my slides and as I'm talking about them, but I think that they're worth visiting. Obviously, if you have a life change that involves the birth of a child or the birth of a grandchild, you very likely are going to want to make sure that your plan covers those folks, because it's likely that your child and your grandchildren are the at least some of the beneficiaries that you might want to benefit from your estate. Similarly, if you get married or remarried, it's very likely that you want your spouse to benefit from your estate. Conversely, and it happens, is if you get divorced, then you are going to want to remove your spouse from your estate planning documents. Now, in California, they are automatically removed in certain situations, but not all situations. And so it's important that you are mindful of that if you are dealing with a divorce. If you have received an inheritance or some other kind of financial windfall, then obviously your estate might be larger than it once was. And what that means is you may be then subject to some taxation that you weren't otherwise subject to when you put your plan together. And so it is worth looking at your plan again and just making sure that you're covered as much as you can be. I get this question a lot, which is moving out of state. So technically, for instance, if you were a California resident moving out of state, the question is, are my documents still good? Do I still have an estate plan? And why, yes, the good news is you would still technically have an estate plan, and it would be a valid estate plan. But I do encourage folks, if they end up moving somewhere and it's going to be a permanent move, that they strongly consider hiring a local estate planning attorney and drafting a new estate plan. And this is because I have, unfortunately, several times in my career, administered through California law, because our California documents use California law, an estate for somebody that has passed away in another state. And so, when it becomes difficult and problematic is sometimes we have to go to court to ask for things or to get things done. And asking, for instance, an Arizona or a Nevada court to deal with an issue applying California law, it gets very sticky. And then you also have the intersection of dealing with, certain types of notices and things that have to be sent per California law, and they often differ than, that Arizona or that Nevada law. And so it complicates things, and it, can result in some issues. And so if you're going to be moving and it's a permanent move, then I recommend you talk to a local estate planning attorney and get those documents created under that new state's laws. Now, as you might imagine, if you have recently had some major health changes or perhaps a disability, you may not need to update your estate plan. But if this is a long-term proposition, you may want to take a look at the provisions of your trust to make sure that you are happy with the succession provisions of people who may be stepping up to help you manage the estate, the incapacity provisions, if it's very likely that you at some point are no longer going to be able to manage your estate at all. And just make sure that, those are as robust as they can be. And maybe if you have a very particular health issue, you might want to address that with some specificity in your documents. And then finally, this is another question I get, if you've been sued or threatened with a lawsuit. So I can't promise you that there's a magic pill in estate planning that if you've been sued or you're in the process of being sued, I can somehow help you shelter all of your assets from that creditor. But for folks who have gone through that, understandably, they may be concerned about creditor issues. And so they might want to revisit their plan if they are concerned for their beneficiaries and perhaps build in some protections for their estate as it is going out to those friends or those family members when they pass away. So I did mention that in addition to life changes, if there are law changes, you may want to review your plan to see if it needs to be updated. Now, I don't expect that you all, the minute you signed your estate planning documents, became tax experts, became tax nerds, following all the IRS announcements and such. But what I am really talking about are the types of changes in the law, in particular in estate planning, the tax laws, where it is affecting most people, or it's affecting enough people that it's bubbling up into the social conscience. And so that's when you're hearing about it on your morning talk shows, you're reading about it in the newspaper or your financial magazines, or folks are talking about it on LinkedIn, your friends are mentioning that they read an article about it. Then you're dealing with a law change that likely could affect your estate plan. And it's a good idea to reach out to your estate planning attorney and see, hey, does this really affect me? Do I need to do anything? I'm going to give you a couple not so common examples, but these are things that I talk to clients about quite a bit, especially when they're coming to see me. And it's really just because of the passage of time. They've created a plan, they sort of put it aside. They know it's been a while. They're not sure if there have been any law changes. So they just want to sit down and talk about their planning. When I am working with somebody whose plan was created before 2003, one of the things that I am looking for is whether or not their plan has appointed somebody as a representative to be authorized to receive healthcare information for that individual. And I'll explain what I mean by that. So effective 2003, the HIPAA rules, which are the federal rules, and the CMIA rules, which are the California rules that are tied to the HIPAA rules, they basically say that if you're a third party and you want to gain access to someone's healthcare information, you have to be designated in writing as a representative. Now, in estate plans now, very often we're building that into your documents. We have sections you can look in your trust or your will, and you're going to see references to HIPAA and CMIA. We love acronyms. So you're going to see references to those, and you're going to see either individual names, or we're going to say, hey, that trustee that I named elsewhere in the document, that person is authorized. And so this is important for a couple of reasons. One is, right now you are master and commander of your estate plan. If you have a trust, you're the trustee and you are managing assets on your behalf. But we do have to plan for the future. And the fact is, it's quite possible that you may become incapacitated, and at some point you are going to pass away. And so we need to have a succession plan in place, which is what your estate plan is for, so that somebody can step into your shoes and they can manage your assets on your behalf or on behalf of your beneficiaries. And if you're incapacitated, they can make healthcare decisions to ensure that you maintain your quality of life. So the issue really then becomes is, during the transition period where we're trying to, get an incapacity determination, for instance, so that your agent can step up and start managing your health care. Well, it would be helpful at that point for your agent to have certain pertinent healthcare information. Similarly, once they become your agent, it is going to be helpful for them to be able to work closely with your doctor and have access to all of your information. Some people are quite shocked to realize that these things are not automatic. For instance, your spouse has no right to your healthcare information. Once your child turns age 18, you have no right to their healthcare information. And so it's important to have either within your estate planning documents or perhaps as a separate estate planning document. This is not uncommon. Sometimes it's called a HIPAA waiver. Sometimes it's called an authorization for release of information. But somewhere in your documents, there should be the references to HIPAA and CMIA to ensure, again, a smooth transition for somebody who's going to step up and manage things on your behalf. Now, when I'm working with married couples, and their documents were created before 2013. And when I say 2013, that seems like yesterday, but yes, that is actually, quite a while ago. But if your documents were created before 2013 and you're a married couple, I am looking for a reference to something called portability. And rest assured, I'm going to explain that. This is a little bit of tax, and then I promise I'm done. I know it's very early in the morning for tax talk. So essentially, if you are a married couple, you're very likely creating a joint estate together, and you consider that estate to be joint. You get to participate in it equally, and unfortunately, when one of you passes away, then the estate is going to, I should say fortunately, then the estate is going to continue on for the survivor. So for estate taxes, it's important to know that each individual has an estate tax exemption. And basically what this means is you are allowed a certain exemption, a certain amount of assets you're able to shield from estate tax. And so what we used to have to do in order to be able to use both spouses' exemption to cover the joint estate and thus ensure that they're paying as little estate tax as possible, is when the first spouse passed away, we literally used to have to carve the estate in half and create two separate trusts. And then we would apply one spouse's exemption to one trust and one spouse's exemption to the other. And then that surviving spouse would, continue to be able to utilize the assets, but they have the administrative burden of dealing with these two trusts. It's more complex, it is more costly. And so what happened was in 2013, the IRS made permanent something that we had kind of been toying with over the couple of years before then, which is this idea of portability. And so what that means is we're looking for an easier way to be able to use both spouses' exemption to cover their joint estate. And so what the IRS came up with is when the first spouse passes away, we no longer have to split the estate into two. We essentially put a pin in that deceased spouse's exemption and we say, hey, we're going to save this for later. And the surviving spouse continues on with the one trust for their benefit. Administratively, it's much easier, as you might imagine. And then when that spouse passes away, they have their exemption to shelter a portion of the trust. And then they're able to go back and gather that deceased spouse's exemption and apply that as well. And that is essentially portability in a very sort of basic high-level view. Now, portability is not for everyone. It is not for every estate either. But for many people who are married, it can simplify your planning and the administration of your estate after one of you passes away. And so when I'm meeting with married people that created their plan before 2013, this is something that I might talk to them about. And again, it's not right for everybody, but it is kind of an important estate planning tool. And so it is something that I do mention. And then lastly, something that's kind of been bubbling up to the surface the last 5 or so years has to do with, I think not surprisingly, digital accounts and digital assets. Now, I know some of you are probably going to say, hey, I don't really have any digital accounts or digital assets. And it's likely true that, you may have less than some of us, with our LinkedIn and our Twitter accounts and our Facebook and our Instagram. But it's quite possible that you save your documents to a cloud-based system, that you pay your bills automatically online or some sort of similar arrangement. And so many of us do likely have at least a few digital accounts or digital assets. And the problem here is really simple. There is not really any kind of uniform California law that deals with these types of accounts. And so essentially what happens is these various businesses have come up with their own default rules, and they're all a little bit different, which can make it extremely frustrating. If your trustee is reaching out to them to get access to your accounts or to get access to your assets. And the default for many of them is they require that somebody go to court and get appointed as an executor, and then that's the person that they will authorize to access the accounts or access the assets. And so many of you who created your trusts, at least in part to avoid probate, avoid going to court and dealing with the court system, this is something that is not a great proposition for you. And so in your documents, particularly if you have a lot of digital accounts or digital assets, it is a good idea to authorize your trustee, your agent under your durable power of attorney, etc., to be able to access your digital accounts and your digital assets, because this authority generally means that those various businesses are going to be willing to work with them and release information to them. So again, that's something that's been coming up the last few years. It's something that we're integrating for the most part. Everyone that I talk to in my field, we're integrating that into our estate plans. Okay, so I have talked a lot about the timeline in terms of when you should be reviewing your documents. I do want to touch a little bit on what you should be thinking about when you're looking at your documents. I want to give you a framework so that when you're pulling it out, you have a starting point, in terms of your analysis and what you should be looking at. Now, the first step is if you worked with an attorney, you very likely got a letter from that attorney. It probably came with your drafts, not your final documents, but your drafts. And this letter likely outlines at a very high level what your documents do, who you've appointed, what authorities you've given them. Now, I say in my letters, and I will repeat it again, that reading that letter is no substitute for reading your documents. But it can be very helpful in giving you a high-level view of sort of the most important parts of your documents and what they do. It can also help refresh your memory, especially if it's been a while since you put those documents together, right? You haven't been in them in a while. And so I recommend that you pull out that letter first, give it a good review, and then have it on hand as you are looking at your various documents to be a little bit of a roadmap for you. So let's talk a little bit about reviewing your will or your trust. Now, honestly, I'm probably going to say trust from here on out, because for most of you, your trust is your main estate planning document when it comes to your financial legacy. Who is going to get what and when and how. You may also have a will, and this is what we call a pour over will in the business. It is a simplified version of a will. And really its only purpose is to be a backup for your trust. And so you're not going to hear me really talk about it again. It essentially says that if any of your assets were left in your own name, that you intended them to be a part of your trust, and so therefore they should be transferred or poured over into your trust. So really, for most of you, the trust is your main estate planning document. And so I'm going to focus on that for this next few minutes. When you're reviewing your trust, I think the easiest way to sort of ease into the process is taking a look at the beneficiaries. So, pulling out your documents and looking at who is going to receive your assets when you pass away. And sometimes there are layers of beneficiaries. So your trust may be set up that it goes to your children. And then if one of your children has passed away, then their children will step up into their shoes and inherit that share. And so you're going to want to take a look at your beneficiary tree and just see, have your thoughts changed as to who you want to benefit from your estate? Sometimes there may have been an estrangement between you and a beneficiary, and it's serious enough that you might want to take them out of your documents. Sometimes you're dealing with a beneficiary that unfortunately has predeceased you, they've passed away. And so similarly, you may want to remove them from your documents. Now, what is really important to take note of is if you have a beneficiary that has become incapacitated, you're going to want to be very careful about how that beneficiary receives any kind of a gift from you. And so if you have a beneficiary that has become incapacitated or become disabled, you're going to want to think about ensuring that whatever gift they receive from you isn't going to be problematic for them in terms of being able to manage it. And also isn't going to perhaps disqualify them from any kind of benefits they might otherwise be qualified for. And so those are really the two biggest dangers if somebody has become incapacitated. And then, of course, as I mentioned before, those big life events, if you have had a child or your children have had children, if there are new people that you want to benefit, then that may be the time to update your estate plan. So, like I said, looking at your beneficiaries is a nice way to sort of, start the process of reviewing your trust, because again, it is the main document in your estate plan. This may take you a little while to get through. The next step after you've looked at your beneficiaries is going to be to look at your distribution plan. Now, this is where that letter is going to be really handy, because that letter should, again, at least at a very high level, walk through what your distribution plan is. And so before you can see if you need to change your plan, you're going to need to refresh your memory about what your plan actually does. And so again, I would reference the letter. And then when you feel comfortable about what your distribution plan is to those beneficiaries, then you're going to think about, is there a reason why I might want to adjust this plan? Very often what happens with the passage of time is just our beneficiaries age. And so what we thought was great for them when they were, 8 or 10 years old, maybe a little bit too much overkill for somebody who's in their 30s and 40s and is grown with their own family and financially responsible. Conversely, if you have a beneficiary that over time has kind of shown that they're not really good at managing funds, then maybe what you might want to do is create some sort of a safety net for them where maybe their interest stays in trust and somebody else manages it on their behalf. You may want to change the plan for everybody if you're worried about, things looking fair between your beneficiaries. And again, if their family situation has changed, if you have children who now have grandchildren, you might want to make sure to include those folks. If they've gotten divorced and you had a gift in there for that spouse, you may want to change that part of your plan. This is not as common, but I do see it happening more with families, which is if you have a beneficiary who's inheriting from somebody else or who has inherited from somebody else. Sometimes what that means is you might want to redirect their share to somebody else with a little explanation in your trust as to why you might be doing so. Or if you have a child who perhaps is benefiting from a grandparent, you may want to adjust your plan just to make sure that everything kind of works together in tandem and that you aren't creating any administrative burden by having sort of different terms than the other trust has, or you aren't creating a tax issue because you are just further augmenting that child's estate because they've already received money from their grandparents. So these are all kind of things to think about when it comes to your beneficiaries, and the plan that you may have created several years ago, and whether or not it works for you today. And I know I promised earlier I wasn't going to talk taxes. I'm going to talk it one more time. I promise it'll be quick. You do occasionally have to think about whether or not the tax landscape has changed. So, as estate planning attorneys, like I said, we do try to build in flexibility, and that includes with taxes. So, your trust, as simple as your estate might be, likely has some sort of tax planning in it. It likely has tax planning for the moment when you sign the documents, and then often has some flexibility, what we call like levers or things that can be activated if the tax landscape changes. And so it's a good idea, though, to take a look at the current tax landscape, because if it's changed dramatically, again, we can't plan for everything. And so you want to make sure that you are covered. If your life circumstances have changed, if the size of your estate has changed, if the tax landscape has changed. In particular, if you're seeing that the exemption is much higher or much lower, it rarely ever goes lower, but I guess it could happen. If it's gone much higher or much lower than it was at the time that you planned your estate, that may be something to think about. All right, so the last thing I'm going to talk about with your trust has to do with, again, the folks that you are setting up to step into your shoes to manage your trust assets if you become incapacitated or you pass away. Again, I'm going to refer to these mostly as trustees because you're very likely dealing with your estate plan through your trust. Here, really, I can't say this enough. It is very, very important. You want to make sure that you still have at least 2 to 3 people named to serve as successor trustees in your documents. Preferably, you have them, lined up to serve one at a time in succession. And this is important because we don't know when these provisions are going to come into play. And so you don't know, at that time, if the folks that you've named are going to be willing or going to be able to act. And so you want to have backups to ensure that you're protected, because the converse is usually that you have to go to court and ask the court, to approve somebody to step up and become the successor trustee. And that's just needless cost and expense. A carefully drafted estate plan will have 2 to 3 people. And so, this is the time to look and see, okay, are any of these people incapacitated? Are they deceased? Have they since expressed that they no longer maybe want to fulfill that role for me? Should I name new people or different people? This is also a really good time when you're looking at your trustees to see, are these still the appropriate people to act? And what I mean by appropriate is, do they have the skills and the wherewithal to take on this role for me? And this is because, when we set up our plans, very often we are thinking, who do we know and who do we trust? And very often for us, that is going to be close family members, perhaps a close friend. And just because we know them and we trust them does not necessarily mean that they're going to be responsible and financially savvy. And these really are the 2 most important skills for somebody who's going to act as your successor trustee. You'll notice I put them first: responsibility and financial savvy. And this is because, being a trustee is not an easy job. They need to step up. They need to be able to, figure out what your estate includes, contact, various banks and institutions in order to be able to take over the management of these assets. And they need to make sure that these assets are maintained and properly invested. And this could be, a couple months proposition if it's just a very quick estate administration and then everything is going out to the beneficiaries. If you're incapacitated, or if your trust when you die provides for ongoing trust, this could be a longer term proposition. And so you want to make sure that, they have the skills to complete these duties as part of their role. You'll see that I put another line item here about being nearby or available to act. Believe it or not, I know everyone thinks we're all living in this grand digital age and nobody has to do anything in person anymore, hence the Zoom video. But the fact of the matter is, because of identity theft issues and other reasons, many banks and institutions are still going to require that your successor trustee come in person to sign the paperwork to take over the management of the accounts. And sometimes there are going to be certain types of actions that are similarly going to require that they appear in person in order to complete. I recently had a situation where I had co-trustees who lived in different states. This is during the current pandemic. And they were asked to come in person together at the same time to sign documents in order to take over their deceased family member's account. And believe me, I get the fact that the bank and institutions are leery about what is going on in the world of identity theft. I do not fault them. This is one of the reasons why I recommend that people appoint folks that are close or are able to travel in these types of roles. But that is just to kind of give you an example of how this can work in the real world. And then just to throw back to what we talked about earlier, this is a good time to look and see if you have given authority to your trustee to receive that pertinent healthcare information. Again, you're looking for those keywords, that HIPAA and the CMIA, and whether or not you've granted them authority to manage digital accounts or digital assets. Now, I do want to touch on your durable power of attorney. This is like your will, a backup document to your trust. But for most of us, this is a really important backup document. I can't recall if I mentioned before, but when you first set up your trust, hopefully your estate planning attorney harped on the fact that there is a second step. And that second step after you sign on the dotted line is you are going to go out and you're actually going to change the title of your assets to your trust. It's like I tell my clients, your trust is only as good as what's in it. Your trust provisions only control the assets that it owns. And so after we've harped on you about that, everything goes into your trust, everything goes into your trust. Well, there are some things that usually don't go into your trust as a general rule. That is going to include retirement accounts like IRAs and 401ks. And so you have to have somebody who is able to step into your shoes if you become incapacitated and is going to be able to manage those non-trust assets. And then, of course, there are times when maybe you didn't quite finish the funding of your trust. You started and life happened, or you acquired new assets and just didn't realize you probably should have taken title in the name of your trust. So again, this is where the durable power of attorney comes into play. You will see, so I promise I'm not going to go through all of these, that the analysis is essentially the same. And that's because your agent under your durable power of attorney and your trustee under your trust are doing the same thing. They are managing your assets. And I always, always, always recommend that you name the same people in the same order in your successor trustee provisions in your trust and in the agent provisions in your durable power of attorney. And that's because if they're doing the same thing, they might as well be the same person. It makes no sense to have two people involved in a transaction if you don't need to. And so again, with your durable power of attorney, the analysis is going to be the same. You're going to look at who you've appointed to make sure you've got enough people there, that safety net for you, that they're still the appropriate people. Again, we're looking at the responsibility and financial savviness of our nominees. And then again, you're going to be looking to see if you can find that HIPAA or that CMIA language and whether or not you've given them the authority to manage your digital accounts or digital assets. Again, I'm going to repeat something that I said earlier, just because if you're looking at your documents, I don't want you to get nervous about this. When it comes to the HIPAA and the CMIA rules, it is quite possible that you have a separate and distinct document that's known as a HIPAA waiver or an authorization to release information. And thus those nominations for representatives would be in that document. And then you might not necessarily see references in your power of attorney or your trust. So just something to keep in mind. Okay, so I do want to touch on your healthcare directive. This is a little bit of a shift from what we were talking about before, which is, looking at largely the documents that control your financial estate. Your legacy, who is going to benefit from it, how are they going to benefit from it, and when are they going to benefit from it? Now we're shifting towards talking more about, who is going to manage your healthcare, your day-to-day living, your quality of life when you are no longer able to do so. And so, some of this is going to be somewhat similar, but we're going to be looking at it in a different way. So again, as a protection, you want to make sure that your healthcare directive names at least 2 to 3 people as potential agents to step into your shoes and again, manage your healthcare decisions. Now, whether or not they're the appropriate people to act, here's where the analysis shifts a little bit. Again, responsibility, is always going to be important. This again could be an incapacity event that lasts several weeks, several months, or this could be an ongoing illness that requires, somebody to really be involved with you in your healthcare decisions for the long term. Here, it is more important than ever that the folks that you are naming or are nearby or at least available to travel to act. And this is because more often than not, they will be called upon to be in person to deal with your doctors, to deal with various institutions that are working with you, the home care assistants or the assisted living facilities. They may be required to take you to those appointments personally. And obviously, we would hope that they would be coming to see you and check in on you and your well-being and all of that good stuff on a periodic basis. So proximity can be very, very important when it comes to your healthcare directives and who you're nominating to serve. Talking about ability to bear the burden of acting, again, the person that is going to be stepping into your shoes is very likely a very close friend or a relative. And so they are very likely also struggling with the fact that you may have now become incapacitated. On a very personal level, they're struggling, as well as bearing the burden of having to make these very personal and very day-to-day type decisions for you. So you want to make sure that this is something that the folks that you're nominating are going to be able to deal with. And then finally, the last one I think is really, really important, is whether or not the folks that you're nominating are going to be willing to carry out your wishes. If you have really strong views about a particular type of care, if you have controversial views about a particular type of care, you're going to want to talk to these people ahead of time and make sure that they're not going to have an issue with implementing that care for you, because if they do, then they're not the right person to be nominated in your documents. So that is something that is very important if you have very strongly held views about particular types of care. Now, in addition to naming an agent, obviously your healthcare directive is your opportunity to list your wishes about certain types of care, to give your agent guidance so they are not just making decisions, based on their own gut instinct and, the information that they get from the physician in charge of your care. I think one of the most important things that you should look at with your documents is how incapacity is determined. So these provisions are going to determine when your agent is actually able to step into your shoes and start managing your care. Now, I do find with older documents in particular that a lot of these documents, the default was that you needed 2 physicians to meet with the individual and go through a battery of tests and then make a legal determination that the individual is no longer able to provide for their own health care. In practice over the years, I have seen that it can be very, very difficult for friends and family members to get an individual into their doctor, let alone two doctors, particularly when they sense what is going on and that their independence may be at stake. And so, again, it is a great protection for the individual to require that two doctors sign off on their incapacity. But administratively, emotionally, it can be difficult for those folks that are trying to seek that determination. And so, of course, it's always a balancing act and it's a very personal decision. But, there are some alternatives out there. You could require just one doctor, provide that legal certainty in terms of capacity. You could appoint what we call a disability panel or an incapacity panel, which is a group of friends and family members predetermined in your documents who can meet and then make a determination, allowing your agent to step up. Or, what is becoming more and more popular, of course, in the right circumstances, is folks are opting to have their healthcare directive be immediately effective, which essentially means that their agent can step up when they feel the time is right and start making these types of healthcare decisions. And then lastly, you're going to want to go through any kind of preferences that you've stated in your documents for life-sustaining treatment, autopsy, organ donation, any limitations you may have placed on organ donation, and just make sure that these are still your wishes, that they still conform to the type of care that you would want to have should you become incapacitated. And if you've included any special wishes or additional information, you're going to want to make sure, again, that information is still current. All right, so this is the last part of the video, last but not least, I like to say, which is reviewing title to your assets. And I'm not going to go through all of these individually, but as I mentioned before, when you create a trust, the second step really is transferring those assets into your trust. Your trust only controls what your trust owns. And so if you're pulling out your estate plan anyway, every 3 to 5 years, this is a good time to take stock of your assets and to make sure that you actually did complete that transfer into trust. So the types of assets that most definitely should be in your trust include real estate, bank and investment accounts, certificated stock, life insurance, business interests, valuable collections that you might have, and any kind of personal property you might own. Now, the good news is when you first created your trust, it's very likely that your estate planning attorney helped you get your real property into your trust. Similarly, your estate plan likely includes what we call a general assignment. And this is going to essentially say that you have transferred through your intent all of your personal property into your trust. And so this is effective as to your personal property. Now, there are some assets I don't recommend that you put into your trust. Over the years, again, this seems to be the current wisdom. We've come to realize that it is very difficult to work with trusts through the DMV. And so any kind of assets that the DMV controls the transfer of, like motor vehicles or boats or scooters, we generally recommend that you use their system for transferring assets. When somebody passes away, it's an affidavit, it is their own form, versus trying to get those assets into your trust and then trying to transfer them to your beneficiary when you pass away. So again, I should note, I probably should have said this a few moments ago, when you're reviewing title to your assets, hopefully the attorney that you worked with gave you a second letter during the planning process. And this letter would have come with your final documents. And that letter, again, is where we tell you, please, 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 there is a second step. You need to fund your trust. And it often lays out the various types of assets that you might own, or if you don't own now, you could own in the future. And it lists how you should deal with those assets, what you need to do to get them into your trust. And so I recommend that you pull that letter out if you have it. Because if you go through the process of, looking at your bank statements, looking at your life insurance policies, double checking your business interests, and you see that something's not in your trust, this letter is going to be a great guide for you. And of course, you can always contact your estate planning attorney, but sometimes you don't have to work with them. The letter is going to be sufficient to give you the information that you need. And then finally, as I mentioned before, there are some types of assets that generally never go into your trust. These are retirement type assets like IRAs and 401ks, and your health savings or medical savings accounts. And that's because these have beneficiary designations. They operate, I like to say, like little trusts. And there are usually tax advantages for using that beneficiary designation system versus putting them into your trust and having your trust control how they're distributed to your beneficiaries. All right, so I'm not going to go through this. This is what I call my estate plan review checklist. I include this here. I'm going to email this to everyone who registered today. Hopefully this is a handy tool. It basically summarizes the last 35 or 40 minutes or so of our discussion, and we'll kind of walk you through at a very high level what you should be looking at in your documents. And then for those of you who may have joined late, I did promise any Bay Area registrants that if you wanted to sign up for a free Zoom estate planning review consultation, you can feel free to reach out to me via email or telephone, and the code review is the code that you will need so that we can get you set up with that presentation before the end of the year. And I am going to go ahead and stop sharing my screen so that we can transition to the